Hello, today's lecture will be about confidentiality and privilege. The objectives of this lecture are to identify the purpose and limitations of confidentiality and to differentiate between confidentiality and privilege. So we'll start with confidentiality. Confidentiality is a legal and ethical consideration that restricts the volunteering of any information about our clients. It is rooted in a client's right to privacy and is at the core of effective therapy. It's our ethical duty as MFTs to protect our clients' private communication with us. This is how we build trust in that relationship. The confidentiality itself belongs to the client. Okay, so what that means is if you have more than one client, so say for example, you're treating a couple or a family, the confidentiality then belongs to the entire treatment unit. So both individuals in the couple, everybody in the family, and so on. So what that means is everyone in the treatment unit who's entitled to confidentiality needs to then give permission to you for breaching confidentiality, outside of the mandated breaches, of course. Confidentiality does not end when a client dies. If you're wanting or needing to breach confidentiality of a deceased client, you must get authorization from their representative, their legal representative. And it's important to be aware that the legal representative doesn't automatically default to a person's spouse. So in the event of having a deceased client needing to breach confidentiality, you would want to get paperwork demonstrating who their legal representative is, and then get their permission in writing to breach the confidentiality of that client. So this is the AAMFT ethics codes that discusses confidentiality. So I'm going to break it down kind of sentence by sentence. So the first sentence says, MFTs disclose to clients and their other interested parties at the outset of services the nature of confidentiality and possible limitations of the client's right to confidentiality. This sentence explains that we inform our clients about their right to confidentiality in therapy and possible limitations, such as child abuse reporting. Second sentence. Therapists review circumstances where confidential information may be requested and where disclosure of confidential information may be legally required. This sentence basically states that we explain possible situations when confidential information may be requested, such as care coordination with a doctor. The doctor's requesting information, we can discuss it with the client and see if we can share that information with them. It's also discussing situations where sharing information might be legally required, such as in the case of a court-ordered subpoena, where outside of a few circumstances, which we'll talk about in a minute, we are required to share that information. So we want to inform clients of these two situations. The third sentence is fairly self-explanatory. Circumstances may necessitate repeated disclosures, meaning that confidentiality is an ongoing process. It isn't just something you discuss at the beginning of therapy and then you don't ever have to talk about it again. Protecting confidentiality. So protecting confidentiality is part of establishing trust. The client needs to know that what they share to you, for the most part, will be confidential in order to trust you enough to share with you. So how do we do this? Well, first, of course, we can't acknowledge whether a person is our client. So if someone were to call you or ask you, hey, is so-and-so your client? You would need to say something like, I can't acknowledge the names of my patients. You can't say something like, oh, I'll have to get authorization from so-and-so before I can tell you, because that then already tells the person that they are your client. So I can't acknowledge the names of my patients, or I can't confirm or deny who my patients are. Something of that sort is helpful. In order to release information about what goes on in therapy, we would need to get a signed release of information, which is abbreviated an ROI, in order to share that information. Without it, we can't share confidential information, with some exceptions. So we'll get to those later. So what that means is, let's say, for example, your client wants you to discuss their progress with their doctor or their psychiatrist. Well, in that case, we would have the client sign a release of information, and then that would allow us to speak to that doctor or that psychiatrist. Without the ROI, we can't share confidential information with others. So that means, let's say, for example, that a client discloses that they committed a crime prior to starting to see you. They broke into someone's house, let's say. We can't report that. That's confidential information. Even though it's against the law, it's confidential. So that would be an example. The only exception to that is if the crime that they committed was against a protected population. So a crime against a child, an elder, or a dependent adult, that we can report. Okay, so I've been hinting at this for a little bit here. So what are the mandated breaches? And by mandated breaches, we're talking about the required. You are required to breach confidentiality or to break confidentiality in these situations, okay? So child abuse or neglect, if a client discloses that they've abused or neglected a child, that is reportable. Same thing with elder or dependent abuse. Danger to others, so homicidal ideation is a mandated breach. If you receive a court order, a subpoena by the court, or a judge-ordered subpoena, in most cases, this will end up being a mandated breach. Investigation by the BBS, if you're being investigated and they ask for your records, you must share them. If police have a search warrant for your office and your records are in your office, then they get to see them. If there's a coroner's investigation about your client and they request your records, same thing, you have to provide them. A formal request from a client's representative in the case of a deceased client, as I've already mentioned, you can provide the records. And then finally, if you are issued an order by the Patriot Act for those records, then you would need to provide them. Permitted breaches. So these are situations where you're allowed to break confidentiality and you won't get into trouble for it for the most part, but you don't have to. You're not mandated. So danger to self or when issuing a 5150. In these cases, you could possibly break confidentiality if someone's a danger to themselves, if it's clinically appropriate. So you need to weigh the benefits and the risks. So for example, doing a psychiatric hold, a 5150, is a breach of confidentiality. And so you'd need to determine whether or not that's the most appropriate thing to do in this particular case. Another example would be like if you're working with a child and you're concerned about suicide risk, you might break confidentiality to talk to their school or to talk to their parents. So you have the option depending on the situation. When you as the therapist need to communicate with other providers for the purposes of diagnoses or treatment in a crisis situation. So the important part here is a crisis situation. So like if a client's admitted to a psychiatric hospital and you're contacted to get information about the client, because it's a crisis situation, you don't need to get a release of information technically, and you are allowed to share information that might be necessary to facilitate that person's treatment in the hospital. Determining responsibility of payment. So this depends on the insurance company. So you will likely need to provide some information to the insurance company if you're billing insurance about the client. You wouldn't need a release of information for this, but it's very limited information that you're sharing. Not really clinical issues, more so when the session was, how long the session was. And then finally, if the client commits a crime against you, like they assault you, they break into your office, in those cases, you are allowed to report their name and relevant information to the police and tell them that they're a client of yours. You're permitted to do that. You don't need an ROI if they've committed a crime against you. So these are permitted breaches, not required by law, but allowed to do. Okay, so let's look at some examples here. You have in this particular one, in the first one, you have family therapy with a mother, father, 14-year-old son, and 7-year-old son, and you're wanting to consult with one of the children's schools. So who needs to sign the release of information? So what's important to remember here is that confidentiality exists for the entire treatment unit. So in this case, your treatment unit consists of 4 people, the mother, father, and 2 children. So in this case, anyone who is 12 and older needs to sign the release of information before you could consult with the school. So the mother, father, 14-year-old son legally would have to sign the release of information to allow you to breach confidentiality. If the child who's under 12, the 7-year-old in this case, you can include them, and that's probably good practice, but it's not required by law. Okay. Second scenario, you're treating a couple, Sam and Blake. Sam seeks individual therapy and wants you to communicate with the new therapist who signs the ROI. Again, treatment unit. So here we have two people in the treatment unit, Sam and Blake. And so even though Sam is seeking out individual therapy alone, you have information that pertains to the couple as a whole. So you would need both of them to sign the release of information in order to speak to Sam's new therapist. And then finally, in this example, you're doing school-based group therapy with 7 teenage girls who are all 12 or older, and the teacher wants a progress update. Who signs the ROI? Again, the treatment unit is the entire unit, in this case, a group of 7 girls, and they're all over the age of 12. So first of all, you're going to need to find out who signed informed consent for these girls to participate in therapy. If it was their parent or guardian, then technically, legally, the parent or guardian needs to provide the signature on the release of information. And of course, it would be good practice to also get the girls to sign the form. If the girls sign their informed consent form independently, since they're over the age of 12, they would be the ones who would need to sign the release of information. Okay, so that's confidentiality. Basically, the client needs to know that what they share with you in session is private and you're not going to share it with other people without their permission, with the exception of the mandated breaches. Okay, so now we're shifting gears a little to privilege, and privilege is a legal term. So this is a client's legal right to not have confidential information revealed during a legal proceeding. I'm going to say it again. Privilege is the client's legal right to not have their confidential information revealed during a legal proceeding. Okay. So privileged communication basically bars the disclosure of confidential therapist-client communications from judicial proceedings or a court of law. Okay. This is different from confidentiality because confidentiality is in place all the time. But if a client never has any legal cases or any involvement with the law, then privilege won't generally come up very much, if at all. The client themselves holds privilege. No matter the age of the client, they hold privilege. If it's a couple or a family, just like with confidentiality, the treatment unit holds privilege. Okay. All right, what are the exceptions? There's actually quite a lot of exceptions to privilege, meaning that these are situations where you would still need to share the person's information in the court proceeding, the legal proceeding, even though they have privilege otherwise. So first, if the client has introduced their emotional condition into court proceedings, they lose privilege. So for example, a client who's suing a company for emotional distress has introduced their mental health into the court proceeding, and so their mental health records are no longer privileged information, and you may be asked to share the information. If a client treats confidential information as though it weren't confidential. So take, for example, you have a client who's famous and they go on Oprah and talk about their mental health treatment and their mental health issues. So this client, this famous client of yours, has treated privileged information as though it weren't. And so now it's an exception that information can be brought into the court proceeding. If a client sues you for malpractice, for example, then their information is no longer privileged. That's an exception. Another exception is if you, the therapist, are court appointed to examine the client, then obviously the report of what you find is going to be shared in the court. And then if a client seeks therapy with the intention of committing a crime or escaping punishment for a crime, that is an exception to privilege. So say, for example, the client explicitly tells you they're coming to therapy because they want to get better at lying to cover their tracks for a crime. That's no longer privileged information. Okay, a couple more exceptions. If a client who's under the age of 16 has been the victim of a crime, then that information is not privileged because children are a protected population, okay? So you would need to share them. If a client is a danger to self and disclosure is necessary, so this is specifically about involuntary hospitalization, okay? If you have reasonable cause to believe that a client's an imminent risk to themselves and they are refusing voluntary treatment, you may need to seek out a way to have them hospitalized involuntarily, and this would be an exception to privilege. You're allowed to provide the information necessary to legally make this happen. A coroner investigation in court proceedings is an exception to privilege. They may require your records. And then if you have been appointed by the court to determine sanity or competency, then this report is obviously not privileged information. So kind of complex. Your textbook gets into all of these a lot more. This is just a general overview. Okay, the last topic here that's related to confidentiality and privilege are subpoenas. And subpoenas are a legal matter. And basically a subpoena is when a judge or a lawyer has requested your treatment records for a client, or they've requested that you testify in court. So you would receive a subpoena to testify or subpoena for records, or both. Obviously, a legal issue. So what do you do if you receive a subpoena? If the subpoena came from a judge, for the most part, you're going to have to turn over the records because it's a judge-ordered subpoena. If you think that releasing the records might be harmful, you can petition for a restricted release that would allow you to only turn over certain pieces of the record. However, the judge could ultimately say, no, I want the whole thing, in which case you have to turn it over. If the judge says, okay, you can give a restricted release of information, then you only provide what's relevant to the case. This is really different from if the subpoena, it comes from an attorney. Okay, so if you receive a subpoena from an attorney, the first thing you want to do is contact the client. It could be that it's the client's attorney and they want you to hand over the records, in which case the client has waived their privilege and you can go ahead and hand them over. But if it's not, you want to find out what the client wants you to do. Okay, so you would contact your client first, find out, what they think about it. If the client waives their privilege, meaning they say, yes, you can go ahead and hand over the records, you would have the client sign a waiver of privilege that puts in writing that they are allowing you to share the records, and then you would proceed forward with sharing the records. If the client says, no, absolutely not, I don't want my records shared, then you would assert privilege and not provide any information about the client to that attorney. Now, an interesting situation can happen where the client says, sure, I want to waive my privilege, go ahead and share the information. But you as the therapist are really concerned that releasing the information could be harmful to them. You definitely want to discuss your concerns with the client in this case. You want to share, you know what, I don't think this is a good idea. I really don't think you should. And the client may say, okay, I won't, and you assert privilege. Now, the client could say, no, I still really want to share the information. In that case, it can be helpful to say, all right, can I have permission to speak with your attorney and share my concerns with them? Assuming they let you, they sign a release of information, you speak to the attorney. The attorney may be able to change the mind of the client, or the attorney may say, no, it's okay, go ahead and share the records. They need to be shared. Okay, so in that case, if the client still wants to waive privilege, you provide the records and be done with it. If not, if the attorney and the client are like, okay, no, we're not going to waive privilege, then you don't provide the information. Now, in that case where you don't provide the information, be aware that a judge could ultimately end up ordering it and you're kind of back at square one again and most likely going to have to share the information. Some final points. Remember who the treatment unit is. The treatment unit holds confidentiality and the treatment unit holds privilege. So for a release of information with confidentiality, everyone in the treatment unit has to sign it. For waiving privilege in the case of a court proceeding, everyone in the treatment unit must waive it. Otherwise, you're not permitted, right? With the exception, again, of a judge-ordered subpoena. If you're subpoenaed to testify, meaning they want you to speak in court, you are absolutely, it's absolutely recommended that you contact an attorney before you do anything else. Okay? And then finally, if you work at an agency and you're subpoenaed either for your records or to testify, your agency will most likely have their own procedures in place for how to handle this. So let them know as soon as possible and defer to whatever they tell you to do. Okay, so let's do an example here. A therapist is treating a client who's involved in a contentious custody battle with his ex-wife. The therapist receives a subpoena from the client's, for the client's records from the wife's lawyer. What should the therapist do first? Think about it. Okay, so remember, if you receive a subpoena, the first thing that you want to do, especially if it's from a lawyer, is to contact your client. Find out what your client wants to do. Do they want to waive privilege, or do they want you to assert privilege, meaning you don't share information? Having that discussion will clarify what the next steps are. If the client wants you to waive it, you think it's okay, hand over what they want. The client doesn't want you to waive it, they want you to assert privilege for them, then you don't share information, and then you move forward from there. Okay, so contact the client first. And I think that's it for this one. Yep. All right, thanks everyone. Let me know if you have any questions.